under 122.1C2, talks about recording or photographing somebody outside the courtroom. It says, in areas of a courthouse other than courtrooms, no one may photograph or record an individual without that individual's express consent. Mr. Ruff, it's been brought to my attention that while you were in the Mason City Courthouse, you personally recorded a conversation with an attorney. You yourself did. You videotaped that person against that person's will or knowledge. You did not let them know that you were doing so. You knowingly and intentionally violated this rule. Even though you know the rule, you did so. So for that reason, Mr. Ruff, you are no longer permitted to record under section 122. Okay, so I'm asking you to shut off your recording device.
What recording device are you talking about?
Mr. Ruff, I'm not asking you to tell me which recording device. I'm just saying you're not allowed to record. So if you have a recording device on.
Why are you so worried about being recorded?
Okay, Mr. Ruff, you're not gonna do this today.
Do what? I'm asking
Mr.
you a
Ruff,
question.
Mr. Ruff, today.
I don't give a speak.
Mr. Ruff, don't push me today. If you have a recording device on, you need to shut it off. The rule is clear for anybody else in the courtroom. We need to receive a request or notice. The court has not received any notice from anybody regarding personal recording. That's what the rule calls for. So I'm directing any of you who are recording, please shut your recording devices off pursuant to the rule. If you are recording pursuant to the rule, since there's been no request or notice made to the court or my staff, I checked with my staff before I took the bench. So I'm asking you all to please do that. If you're caught recording, you'll be asked to leave the courthouse. Ralph, let me go ahead and address just some of your motions, because there were some notices, and I don't want to not address them since you did file them. There was a notice to the court which was filed on, looks like June 6th. There was a motion, Mr. Ruff, that you had filed emergency procedural motion to refer to the Superior Court of normal inspection of record, emergency stay of proceedings, request for court appointed counsel. I guess you were filing that under Rule 8 of the Superior Court Rules of Criminal Appellate Procedure. So this is something that is intended for the Superior Court to address. But let me go ahead and just address your notice to the court. I know, Mr. Ruff, that you had indicated in your notice that you had never received a proper record to do the appeal. So what I wanted to do, Mr. Ruff, is just briefly go over, because I wanted to look over your cases and just make a record so that it is clear. In the 4 cases, Mr. Ruff, where you were found guilty and sentenced, you had, in 3 of the cases initially, and I'll reference those cases. There was case 2021-071-040 and case 2021-048-968 and 2021-043-799. There was a court-appointed attorney appointed in that case in December of 2021. A lawyer had filed a motion to withdraw. Then you had retained the services of a private firm by the name of Mays Tellis. They had filed a notice of appearance in January. And they were representing you in all 4 of the cases. On the 3 that went to trial on May 26th of 2022, in fact, 2, you didn't have 1 attorney, you actually had 2 private attorneys here from that firm representing you. And what I wanted to make clear for the record, Mr. Ruff, is in these cases, there were no pretrial motions. There were no evidentiary hearings. There were no oral arguments on any motions because no motions had been filed. The only motion that had been filed in any of those 3 cases, whether there was 1 motion for a deposition of an officer when the interview had not been conducted. However, that motion was deemed moot by your counsel because the interview later took place. So just for the record, there were no pretrial motions. There were no evidentiary hearings. And so the only issue was the trial. The trial took place on May 26th in those 3 cases. You had private counsel. Like I said, you actually had 2 attorneys. That firm had filed a motion to withdraw then after those trials due to irreconcilable differences with you, Mr. Ruff. And then after the sentencing, they were allowed to withdraw. The other case, which was set for trial in August, again, you did have the Mays Tellis firm. However, their request to withdraw was granted, and then you represented yourself in that matter. But prior to that time, there had been no contested motions, there had been no evidentiary hearings, there had been no oral arguments on anything pre-trial. So the only thing, Mr. Ruff, that was going to be appealed in this matter was obviously what occurred during trial, or what you may have disagreed with during trial, and what you may have disagreed with in terms of the sentence that you received. And according to your notice to the court, Mr. Ruff, I noticed that you simply referred to Rule 7C regarding items that you believe that you didn't have to do your appeal. However, you had everything to do your appeal. 7C refers to items that the clerk then has to transmit to the Superior Court once the appeal is perfected. The appeal is perfected, Mr. Ruff, once a memorandum is properly filed, then the clerk merely sends those. Let me go over those items. Those items are a notice of appeal, Mr. Ruff, which you had because you're the one who filed the notice of appeal, so you obviously had your own notice that you filed. There's what's called a docket or list of events, and that's just where the clerk merely prints out the list of things that occurred. That's under C2. There's a documentation of record of payment, so if there's any fines, restitution, or bond that you had paid, that's simply they send notice that you paid those. However, there was no bond in any of your cases. No fine had been paid, nor was there any restitution paid. It says that the charging document has to be sent to the court. Obviously, you and your attorney from day one always had the charging documents. You knew what you were charged with. You had the complaints. You've always had those matters. Under item 5, it says disposition or judgment or sentence. Obviously, Mr. Ruff, when you were sentenced, there was that matter was recorded. There was a transcript of those proceedings. Also, you received the judgment and sentence. You were given that the day that you were sentenced, so you had that item as well. And then it says 6, the order or judgment or ruling that is the subject of the appeal. The ruling or subject of the appeal would have been your sentence that I imposed, which you had fully, and the transcript, as well as the trial transcripts. You had those items. Item 7, any written motions, responses, or replies. We've already gone through that. There were no contested pre-trial motions. There were no contested pre-trial issues in your case. There were none filed by you. There were none filed by your defense counsel, including your private defense attorneys, that private firm that you had retained. Any exhibits, which obviously the parties had. And then it says the recordings or certified transcripts of the trial and the sentencing order, which you had. And the last, if designated for inclusion by a party, oral argument on motions, voluntariness, suppression hearings, aggravated or mitigation hearings. Again, most of those things just did not occur in your case. Those things were absent. So you had all the documents, Mr. Ruff. You had more time than most individuals in this entire city of Mesa are ever afforded to do an appeal. Judge Tatz denied your motion for stay. Judge Tatz found that you abandoned your appeal because he gave you yet another extension of time. And since you did not file that memorandum, he felt that your appeal was abandoned. So the only thing I can do this afternoon, the only thing legally I can do, is to reimpose sentence. I have nothing else that I can do at this time. So I just wanted to make the record clear for that. And I did notice, Mr.